Josefa, I think, before we go any further with this discussion on collaboration, we should probably discuss intellectual property, right? Because that's a core
Definitely,
component of.
definitely.
So, any thoughts on that, the nuances of how this works?
Sure. So most of the current cross-border transactions, or close to 70% of them, are circling or have some connection in relation to intellectual property. When we talk about a technology collaboration or a technology transfer, what forms the bedrock of that relationship is intellectual property. Our clients often ask us that is there anything special in relation to Indian IP laws, or are there any specific nuances under Indian IP laws? The answer is twofold. India is a jurisdiction which is broadly TRIPS compliant in relation to its intellectual property laws. However, there are certain intellectual property laws which have certain local nuances which are probably not there in other parts of the world. So I'll take the example of the Indian Copyright Act, which broadly covers computer software, databases, know-how, written algorithms, and things which are not usually, patented or not covered under designs. So any Indian copyright, when it's involved in a technology collaboration or a transfer, if it needs to be assigned, the document has to be in writing and signed by the assigner. That's a specific nuance under the Copyright Act. Secondly, another interesting thing is if the assignment term and territory is not specified, the term is deemed to be for 5 years and the territory is deemed to be India. The same logic applies for licensing arrangements as well. So whenever there is an Indian copyright which is licensed, if the term and territory is not specified, it's deemed to be 5 years and India. So whenever our clients or whenever we advise people that when they're doing their documentation in relation to certain IPs, Indian IPs, we need to ensure that these sort of nuances are covered. Moving forward, the requirements of registration also get quite important. In India, whenever you're acquiring a company for its brand name, which is also called as trademarks, when you take over that brand name or when you buy that brand name, there is a requirement to go and inform or file the assignment or the acquisition trademark deed with the trademark registry. Similarly, under the Indian patent law, there is also a requirement that whenever there are any rights and obligations which are being created on an Indian patent, the same needs to be recorded in writing, and that's specified under the Indian Patent Act. And once again, you need to inform the patent registry. So these are some of the nuances which I thought would be very relevant. If we are having a technology collaboration or a technology transfer from a cross-border perspective, that we are mindful on these fronts.
So, it sounds like documentation is a very key aspect of these arrangements then.
It's extremely critical. And as we move forward during this webinar, we'll also touch base upon what are the finer points which you need to bear in mind when you're doing the documentation.